I'm Molly Muntz, a licensed insolvency practitioner at Parker Walsh. So this topic is usually quite a nervous one for directors. I know it is during the initial advice that we give, that directors are very nervous and they're worried about what I'm going to say. So this video is regarding the director's conduct and what happens in, say, a liquidation scenario. So most of the time, there's absolutely no need to be nervous. There's no need to panic. And let me explain to you what we look at and the reasons for it. And then usually in the initial advice, I then ask the directors, what are you worried about? Let's have a look at it and let's see, let's analyze this transaction that you're worried about and see what might happen and what can you do to rectify it. And as I've said, it's usually such a relief with the directors because they've been worried and you can make it worse in your head. You lose sleep over it. I've had directors worried that they're going to go to jail, they're going to lose their house, etc. And, most directors have done everything that they could for the company. They wanted it to survive. It's their livelihood. Of course, they wanted it to be successful. So most of the time, people are worrying over nothing. So the director's conduct does get looked into. It gets looked into by myself as liquidator and also by the Insolvency Service, and that's a government body. And essentially, we just need to check that everything was done correctly, because creditors most likely aren't going to get paid any of the money they're due, and they just want to have a reassurance that the director didn't take all the money out and go on holiday to the Bahamas when they should have used that money to pay the creditors. So essentially that's why we're doing it. And every director of the last 3 years before either an administration or an insolvent liquidation gets looked at. So you can't just resign just before it goes into liquidation and think that absolves you. So it's every director of the last 3 years. So the Insolvency Service, their role is to look at the conduct of the director to see if disqualification is appropriate. And disqualification is, prohibiting a director from being involved in a company as a director for a period of 2 to 15 years. So you can be disqualified as a director for 2 to 15 years. And what they're doing is they're protecting the business community and the public, because maybe you've done it many times before. Maybe you've taken deposits off little old ladies and then not carried out the work that you were supposed to. The insolvency there is to protect the business community and the public. So they would say, no, you keep on doing it. It's poorly managed. You may not have even had a genuine reason to set up the company. You were purposely doing it to extract money. And that's got to be stopped. And I think we can all agree that's quite sensible. So that they are looking for those things. And then as a liquidator, I'm not here to punish a director, but what I am here to do is to make sure that if you've taken any money out of the company when you shouldn't have, that you're repaying it, and that's only fair. So there's two sides to this investigation, as I've said. The Insolvency Service to see if disqualification is appropriate because it's in the public's interest to stop you from doing it again. And then my purpose, my role as liquidator is to recover any money that you took out of the company when you shouldn't have. So what does that look like? So that can be an overdrawn director's loan account. You've taken money out, and as it says, it's a loan, you have to repay it. But it could also be other transactions. For example, if you had a motor vehicle, a company vehicle, and it was worth £50,000. There was no equity on it. It was just a company vehicle that it owned, £50,000. And then you sold it to your brother because you quite like your brother and he wanted it. So you gave him a really good deal and you sold it to him for 10 grand. So that's a transaction at an undervalue. You shouldn't have done that. That's not fair when you're not paying your creditors, that you've allowed an asset to be sold for less than what it's less than what it's worth. So that could be looked at, and you might have to, obviously make up the difference for it. So it's important, obviously, to sell things at a fair value. And then there could be a preference payment, and that's essentially where you say you have 5 creditors. They're all owed £1, and so you owe £5 to 5 creditors. You've got the milkman, you've got HMRC, you've got a supplier, you know, a typical array of creditors. But one of them you might really like, and it might be your sister-in-law, for example. And although she is owed that, that pound, and you've got your 5 creditors and you've got £1, and instead of distributing it equally, splitting it amongst them all, which would be fair, you give that pound to your sister-in-law because you like her and she's a relative, etc. That's a preference. It's not fair on the other 4 creditors. They were owed equal amounts. They were all owed money, so why did you prefer that one? So that's a preference payment. So again, that would be something that we would look at. And there are various transactions. There's quite a broad one, which is known as misfeasance, which is misapplying company money. It's maybe where you didn't intend to do something incorrectly, but you did. You're the director. You're ultimately responsible for the company. And so that there are lots of transactions that that you might not realise, but they will be looked at and scrutinised. And what I would say is, if you are worried, speak to an insolvency practitioner like myself. We can run through it. I can tell you how to remedy it. And it's always useful to speak to someone like myself. I know it's a big step and you can worry. I had a liquidation and they were worried about a payment that they made. It was actually a payment they made 15 years ago, but they'd got that worked up. It was a husband and wife, that they weren't sleeping. They thought they were going to have to repay it, and they started to look at their retirement pot to see if they could extract the money to put back in, and it was absolutely fine. So we can give that reassurance. But it also is a really good sounding board for you as well, because if your company's struggling a little bit, but you are going to continue to trade in the hopes that obviously it becomes profitable again, but you might want to avoid these transactions. So again, speak to an insolvency practitioner because we can give you advice about that for future transactions. So you could come to me, for example, and say, look, my company is a little bit in trouble. I'm really struggling, but I think it can return to profitability. I have this company vehicle that I no longer need. It's 50 grand. My brother's offered 10 grand. I know it's less, but I know he's good for the money. I know he can get 10 grand. What do you think? Then I can advise you rather than walking blindly into that transaction and it later on coming back to bite you. I can advise you on it. And it might be that, for some reason I do agree with that transaction, that it's, the money's there, the vehicle's not actually worth 50 grand, etc. I can give you tips on how to protect yourself. Taking pictures of the motor vehicle, take pictures of the mileage, take pictures of the registration, get online valuations, practical tips like that I can help you with. So it's always best to speak to a licensed insolvency practitioner. Okay, so just in conclusion, there are 2 roles here. There's the Insolvency Service for misconduct and whether or not disqualification might be appropriate, and my role as liquidator to see if any of the transactions were done incorrectly and if the director owes any money back to the company. But if you call me early on, before it's in liquidation, I can advise you on previous transactions as to best to how to remedy them and what might happen, and then future transactions, if you're continuing to trade, how to do it best. Okay, so I hope that's helped. Thank you.